I was asked to make some remarks on the state of the judicial precedents on adolescent health challenges and opportunities. But I have to say that as a judge, I can only stand before you here to talk about what judiciaries in Africa should and can do about adolescent health. And we can only do that as judges if we speak about what we are doing in terms of jurisprudence, which is case law, what are the cases that have come before us, and what have we said about reproductive rights and health, and also structurally, as a judiciary, how are we handling these cases, and what is our corporate culture around handling reproductive rights and health matters that come to the judiciary. I want to say, as a starter, I think Kenya, we are fortunate that we have a new constitutional dispensation. It's not that new, actually. In 2010, Kenyans went into a referendum and they adopted a new constitution that did several things for the justice sector. One, it ring-fenced the judicial independence. And now judicial officers may sit and hear matters without intervention from interference from religious sector, from the political sector, from the other sectors which, as you have heard, have interests in rights for their own agendas and not, strictly speaking, for the beneficiaries or people who should be the beneficiaries of those rights. So in Kenya, we're very fortunate that we have a constitutional dispensation. And as you go back to your countries, for those of you who are here from the rest of Africa, I think you need to explore what is the constitutional dispensation in your countries, and does it allow for the independence of the judiciary, for the decisional independence of judicial officers when it comes to reproductive rights and health? Secondly, structurally, this independence, of what use is it if judiciaries themselves do not sensitize themselves on those issues, but also look inward? I'm happy to say that in the Kenyan judiciary, we adopted a sexual harassment policy. We have adopted a gender and inclusion policy. We have an affirmative action policy. And these are now structured into offices in the Office of the Chief Justice, where it's easier to report sexual harassment cases, but also helps to sensitize and help our culture as judicial officers. Do we have challenges? Yes, we've got plenty of challenges. Sometimes judicial officers bring in their values and their cultures into decisions that we make. We have an infamous case where sex crime took place, a 14-year-old who had been defiled, and the judge said in his judgment that because she was well-rounded and looked like a woman, she was a woman. And he released the person who had been convicted of that defilement. But the challenges are there, but we've also made some progressions. For example, in the Kenyan judiciary now, we have rolled out 12 specialized SGBV courts. In fact, there's the one that is full-time, and we started off, is just about a kilometer from here in Shanzu. And I would welcome you to have a look at it, where the judicial officers are trained, the victims of sexual, gender-based violence are handled properly. They're able to do pre-recorded evidence, which is taken into evidence, and that will assist in the issue of re-traumatizing, the possibility of re-traumatizing victims of violence. We also have a judicial bench book now on trafficking for sexual exploitation, and we have done some training. We still need to do a little bit more training, and I want to thank those organizations in Kenya that have helped us. But apart from looking at us structurally and how we are engaging on reproductive rights and health, I think it's important to look at case law. And again, our case law is informed by our constitution. The Constitution of Kenya is very clear that the judiciary, which is the guardian of the constitution, must implement the Bill of Rights. And we have, in writing, in the constitution, well articulated the protections, the right to life, the right to health, the right to consent in marriage, the right to equality, freedom of conscience, and the right not to have others impose their conscience or religion on you. We have the right to privacy, the right to human dignity, the right to bodily integrity, the right to education information. All these are reproductive rights which are contained in the Constitution of Kenya. Further, the Constitution of Kenya recognizes that any treaty or convention that has been ratified by Kenya becomes part of Kenyan law. And therefore, when courts are looking at the laws of Kenya, they look also to the treaties and conventions which Kenya has signed. Specifically, in the Constitution, we have Article 43, which provides in particular to the right to health, including reproductive health and emergency medical treatment. So how has this worked for us as judicial officers look at the Constitution and apply? Now, I'll try in the simplest of terms. Often we're accused as lawyers and judicial officers of using long legal language. I want to just give you a snapshot of some of the cases that we have looked at and some of the decisions that have been made. Some of the parties are in abbreviated form because of the confidentiality, just like we do in family law. So in the case of PAK versus the Attorney General, it's a recent 2022 case, the court held that abortion is a right and patients and health providers may not be arrested as they are providing this health care. There is another case, FIDA versus the Attorney General, where the Ministry of Health had guidelines on abortion health care, which were withdrawn in 2014. The High Court has found that those guidelines are constitutional, should be provided, and the Ministry of Health should set up procedures for which women and girls can have abortions as provided for under the Constitution of Kenya. There are grounds under the Constitution of Kenya in which abortion, whether or not it is being rolled out on the ground, is something the Ministry of Health, who is here today, will tell us, but the courts have been very clear, and as you hear the Chief Justice saying, we expect court orders to be obeyed. The courts have also looked at the issue of HIV/AIDS. In the case of VMK versus the Catholic University of East Africa, the court made a finding that you cannot discriminate on the basis of a person's status that they are HIV positive. Similarly, in another matter, the courts have found that the government, again the Ministry of Health, could not issue or could not conduct compulsory testing for HIV/AIDS on school children. They found that there is a right to privacy, and whereas government must get that data, they cannot get the data by force. That there has to be some kind of informed consent, and it has to be voluntarily given. The courts have also made a finding on the issue of IVF and surrogacy. Kenya has no law on surrogacy. However, in JLN versus the Director of Children's Services, the courts made a finding that it is in the best interest of the child for the child to be given to the biological parents and not to the surrogate, because there was a conflict between the surrogate and the biological parent. We have, of course, as a judiciary, asked Parliament to legislate on this, but this has not been done. But we have made the finding that the surrogate parent has no rights over that child. We have made some findings on family planning. There was the case of AAR versus registered trustees, where this woman went to the hospital, said that she did not want to have any more children. The hospital assured her that they would put an implant. A few months later, she was pregnant. When she checked with another doctor, the implant had not actually been put. And therefore, she sued the hospital for, among other things, having to bear the cost of having another child. And the court did award her damages. The hospital had to pay her. Currently, there is a current case which has not yet been determined in Ndimuli versus the CS Health, And that main question is whether you can have parental consent for contraception for teenagers. So we await what the courts will determine in that matter. On the issue of forced sterilization, there is the issue of LAW versus Marura, in which case the patient was diagnosed with HIV during a prenatal examination. The nurse suggested to her that because of her condition, she ought not to have other children. Proceeded then to give her 2 pieces of paper, one written TL and one written CS. And when she went in to have her baby, she had the cesarean section, which was CS, and she had the tubal ligation, which was TL, but she didn't realize it was a TL. Much later, she was trying to have more children. She realized she had had the TL without her consent. The courts have found that the government, the Ministry of Health, doctors have to have informed consent where such a serious reproductive rights issue is concerned, and she was issued damages. There's an interesting case in the county of Bungoma versus Josephine Ongwen. This lady went in, she went to have a baby. In the hospital, she was insulted by the nurses, she was left alone, she wasn't given anything to manage her pain, and she took the county to court. And the courts found that indeed she had not been treated, that there is a basic care that medical professionals owe their patients, and that she had not been treated correctly, and that the medical profession has to pull up their socks on this one. Again, she was awarded damages. And there is an interesting case relating to FGM. So in Tatu Kamau versus the Attorney General, there is a woman who went to court and said, I think it's my constitutional right to circumcise. I want to be circumcised. It's my constitutional right. But the courts found that you can't really have the right to self-harm. And therefore, she has no rights to circumcise self or other. We have also, in the courts, dealt with rights of intersex, where the case of Baby A versus the Attorney General, the courts have directed the government to register a third gender. Male, female, and intersex now becomes an official gender that needs to be, when one is being registered during birth or any other gender designation. The courts also have talked about the rights of trans. There was a case where a trans woman wanted to change her name on her examination certificates, and the courts have found that she should be able to do that and directed the examination council to register her as a woman and to change her name into a more feminine one, which she preferred. Of course, in the Court of Appeal, there has been a decision about how to treat a suspect. In this particular case, 2 gentlemen had been arrested on suspicion of being gay. They were subjected to anal examination. They were forced to undress in front of police officers, and they went to court claiming that their right to privacy and dignity had been violated, and the courts found for them, said that there is a certain standard and that courts must first convince themselves before they order for such a test that there in fact is a crime. And in these circumstances, the court found that a crime had not yet been proven. Finally, in the Supreme Court recently, we had this case where the NGO board had refused to register an organization which advocated for LGBTQI, and we determined that you cannot limit the right to associate in this country under the Constitution based on sexual orientation, and that sexual orientation is a ground under the Constitution on which you may not discriminate against a citizen of this country. Now, like I said, it's just a snapshot of some of the work we've been doing. I recognize that in many of the African countries, they haven't progressed as far as we have in reproductive rights case law. South Africa, I think, is an exception. But again, it just goes to show how judiciaries can impact on reproductive rights and health. And I want to encourage everyone here to be able to go back to their judiciaries and see what those judiciaries can do for them. There is, however, need for funding of public interest litigation. And indeed, I want to mention the Center for Reproductive Health, IPAS, and FIDA for the good work they've done by bringing these cases, because courts cannot move themselves. We have to be moved on issues. I think I just want to conclude here and just say, as you go back to your countries, also encourage the training of your judicial officers on these issues of reproductive rights and health. Let me end here. I hope to participate on other larger issues. For me today, I've been constrained to my judicial role, and I thank you.